Welcome to the program. We're going to cover a really important and timely topic that has not received nearly enough attention. In fact, I would even suggest it's a bit of the Rodney Dangerfield of estate planning, the step transaction doctrine. Joining me for this program, I'll start with the people wearing ties, are Robert Keebler, Alan Gassman, and Thomas Tietz, and the other relaxed looking fellow is Jonathan Blotmacher. So we're going to get started. Just a quick couple of comments. There's no formal CLE or CPE credits given, but we do issue a certificate of attendance if you can self-report. Recordings of the program will be posted to my website, the Peak Trust Company website, and the ILS website, our two sponsors. And if you have any questions, the best thing is to email the speakers directly. We're all pretty findable. Jonathan, why don't you make a quick comment about ILS to kick us off?
Well, I've been working on this ILS program, which allows lawyers to basically automate its drafting and even intellectual decision making for lawyers. It's, I think, a wonderful system. That's why I got involved with it. There are now thousands of lawyers that use it, and many of us have told me that they would sooner give up their secretary or their paralegal than the system. There's no question the world is changing, and it's changing with respect to artificial intelligence, and ILS is part of that. And if you haven't looked at it, I urge you to give it a try. You can call Mike Graham at the number on your screen, or email them at sales@interactive.com. Thank you very much.
If you haven't automated, and I'll speak even more broadly than ILS, I personally use ILS, but if you haven't automated the crush of potential estate planning, depending on how the election pans out, could well be one of the, and hopefully we'll know by the time we, at any rate, this is a way for incredible efficiency. If 2026, and I can't imagine the exemption not going down, but it's possible. But the crush of planning for 2026, automation is going to be the key to handling that work. And our second sponsor is Peak Trust. Jonathan, I'll make a comment and you can add, and the contact information for Andre is there. Peak is an incredibly efficient and responsive administrative trust company in Alaska, Nevada, and Jonathan, aren't they in Delaware now too?
They're getting there, Marty.
Okay, so soon, but in Nevada and Alaska, two of the top states. And if you're looking to differentiate trust from the reciprocal trust doctrine, which is not our topic today, using different jurisdictions is great. If you're looking to add components of hybrid DAPs, DAPs, or SPATs to your plan, so it's not merely a SLAT plan, you want to be in one of the trust-friendly jurisdictions, and Peak is well equipped to be very quickly responsive to your needs. Jonathan, is that good, or you want to add something?
Well, let me just add that all of the states now, and I think we're up to something like 22, Marty, that permit a person to create a trust for his or her own benefit. That is, you create or settle a trust for your own benefit. That's called a self-settled trust. I, of course, have been the sponsor in the United States and oversaw having Alaska adopt it. And then Delaware came on, and South Dakota and Nevada, and now we're in 22 states. I have sent hundreds of clients to Peak, and even though my nephew runs it, that's not why I think it's terrific. I find them extremely, extremely helpful. They have great people, but they really care. So you ought to give them a trial if you want to get something done. And whether you're in Florida or Maine or California or Washington State, you can use Peak Trust in Alaska or Nevada without any hassle whatsoever.
So let's get going. Alan, do we have, sorry about that. Alan, I think we have some potential changes coming up with the sunset. And that kind of lays the foundation why the step transaction is so important to talk about. And everybody, it's really critical to address before the end of this year. There's still going to be a little bit of time left. Alan, what's coming up? And then we'll set the stage for why the step transaction is so important to address.
Well, the estate tax exemption is going to go down by half January 1st, 2026. So you need to wait, you need to act before New Year's Eve to call your lawyer to talk about what you're going to do to salvage your bonus exemption. Right now, the exemption of 13,610,000 is half temporary and half regular. And you've got to burn through the temporary and any portability allowance before you can get to the part that's going to be gone January 1st, 2026. So how do you make that $14 million gift in 2025? Well, it's probably a good idea to have $14 million worth of assets. And where are you going to get that $14 million worth of assets? Maybe from your spouse. So who's making the gift? Is it you or is it your spouse? And I think that's where you want to kick off here.
So a lot of people, and to me, this is one of the key points of this whole program, which is simple, and I know everybody understands it, but that's why talking about step transactions is so important. I've heard so much discussion of reciprocal trust, very little about step transaction. But just as Alan said, if you're retitling assets between spouses and then making a gift, you got to have consideration of the step transaction doctrine, or the IRS could collapse it. We're going to talk about the Smaldino case in a bit of time. That's really one of the important cases that addresses all the things that have been done wrong. Jonathan, give us a little bit of introduction as to why, and Bob, you should comment as well. Why is it important to try to take action? There's not a lot of time left in 2024, but why do we care? Why is it important for people to think now? I think a lot of people have focused on, all right, I have to the end of 2025 to do my pre-26 planning, but that misses the point of the step transaction doctrine. Jonathan, then Bob?
Well, there are 2 points to that, Marty. Number one, if your steps are very close to each other, like you have your spouse give you money and then you make a gift of it or enter into some sort of transaction with that, if they're close in time, probably the most important factor of all is the timing of it. What you contend are different steps. You run a risk of not having them respected. It means your spouse would be the one who is deemed to make the transfer, which can cause estate tax inclusion if he or she is a beneficiary of the trust, or worse, is given a power of appointment. Because unlike 2036, where if you create a discretionary trust, it's at least arguable that the 2036A1 provision, which causes assets to be in your estate, if you've made a transfer and retained an income interest, won't apply. But if your spouse has a power of appointment in that trust, you've created it nominally, but the IRS convinces a court that really, because it came from his original assets, she or he should be treated as the transfer of that property. And if he or she has a special power of appointment, you probably inclusion under sections 2036A2 and section 2038. Very, very important. And as I said, there's no time that we can get to which says, well, if you do it this far apart, you're going to be okay. And we'll get into that a little bit in a while.
Bob, just some comments on why people, even if they'd rather be away on vacation for the rest of the year end, why people want to act now, why advisors want to reach out to clients and try to get steps taken in 2024.
A lot of this overlaps with what Jonathan just said, but gifts between spouses, if I'm going to gift something to my wife and then expect her to make a gift of that same property 14 months from now, very dangerous game, but the more time between those steps, the better, A. B, if I'm going to create a slat for my wife and she might do the same thing for me in December of 2025, we'd love to have 13 or 14 months between those steps. And then finally, Marty, let's say you only have one child and you're a 90-year-old lady, you're trying to transfer a business to your 60-year-old child. If you make a 50 or 55% gift, you're going to have a minority gift, okay? You're not going to get any discounts. On the other hand, if you would gift 48% in 2020 and the other 48% in 2025, 13, 14 months apart, you're in all likelihood going to get discounts on both those transactions. So there's a lot going on here, and this is a super important subject, especially for CPAs signing gift tax returns. You can't ignore this. If something's not done, if you don't like how something looks, you have to talk to the lawyer that put that plan together and work with them on how you're going to do those gift tax returns.
Let me make two, Marty, let me make two additional comments following up with what Bob said. 14 months would be terrific, but the fact of the matter is that the Congress will sit around January 20 of 2025. It is exceptionally rare for one Congress to retroactively pass a law that applies to when a different Congress was sitting. Remember, on January 20, we are going to have a new Congress, and it's very rare for that new Congress to say, we're going to change the rules retroactively. It has happened, but it is exceptionally rare. Second is you just can't count on the discount. Bob is right, you'll probably get it. But there are two cases, Blanchard and Driver, which suggests that you may not. There was one case where they made one transfer in one calendar year and made another transfer of another interest in the property the next year, but within the first few days of the year, and the court collapsed those. Basically, they said, we will treat it as one step for purposes of discount, and they denied any discount. Time is probably your most important factor, but again, if you're going to try to make your transfers before the new Congress sits, which will be around January 20 of 2025, you really need to start acting very, very soon.
Bob, comment on something that, and maybe it's a fallacy, and I've been under a fiction and a misimpression my whole career, but I grew up for a long time in accounting. I worked in a CPA firm to work my way through law school at night. I've always had this feeling, boy, let's say you can only get 30 days between a transaction. I've done transactions with less time between them, despite what all of you are saying. And I've just put the client on notice. There's a risk. We can't weigh the risk, as Jonathan correctly said. There's no magic number of days between transactions, but there's something as a CPA that always made me feel good if I could get something done in one tax year and something else done in another tax year. And that's kind of why, from my sort of, maybe, and correct me if you think I'm wrong, but as a CPA, I always kind of felt, you know what, if wife is going to make a gift to husband and husband's going to make a gift to a trust, yes, I would like as much time as between as I can, and that's going to get compressed as time moves on. Yes, I want different events, and we're going to talk about that, so I don't want to jump that gun. But I always felt, boy, if the wife made the gift in 2024 and I have the reporting that on the income tax return as it's, her his asset in 24, but he doesn't make the gift till 25, that just seemed to make me feel more comfortable. Any thoughts on that? Is there actually any law that supports it, or is that just a myth that I've always kind of felt happy about?
Well, Marty,
No, let Bob comment first,
Okay,
Jonathan.
Bob, go ahead.
I think it's a myth. Imagine I make a gift in December and then another gift in January. Those are going to be a month apart. Those are different years, but they're certainly going to be easier to collapse than a January-December gift in the same year. So I think why CPAs like that is because when you're looking at one gift tax return, you only see the gift of 48%. And then
Right.
Unless you look at them next to each other, you don't see the other gift of 48%. And easy to glue together in your mind. Everybody knows what happened. But so I would prefer to put more days between that than just December, January. Now, if you could gift December 1st and December 30th versus December 1st and January 1st, I don't think there's a lawyer or a CPA in the country that would not take spreading it out over 2 years.
Jonathan?
Well, keep in mind that, the IRS is going to be looking at returns. And if you have one return which shows both transfers, one of the husband, one of the wife, Well, then you have a greater chance that the IRS will look at that carefully. If you do one by the wife in 2024 and one by the husband in 2025, the chance of the IRS even looking at those as connected goes down. You may not really be able to tell me how much it is, but you do get extra credit for timing in different years.
Yeah, it always makes me more comfortable to spread transactions to different years. And what's important to me about that, as apropos to our topic today, is that's why I think these waning days of 24 are just so important. I want as many days just like everyone. We can't control that. Clients will often show up at our door and we won't have any time between. That's their risk and their decision to take it. But if I can get people to do some of the planning in 24, I feel a lot happier about it. And yes, I like the idea of different tax years, even if it's a myth. So that's one important point. What is the step transaction doctrine?
Marty, could I just make one quick practical
Sure.
point about the timing? So if you have a transaction that's more complicated than just transferring marketable securities, you have an LLC, there could be third parties involved in that entity. There could be restrictions on those transfers. The earlier you get the process started, the easier it is to get everybody to sign the numerous multitude of documents that need to be signed in order to effectuate those transfers. You don't want to get into a point where you're trying to get the first transfer done, but you can't track down one of the third parties, and now you're reducing the amount of time you have between the transactions.
So let's now a good point. Let's now address, Jonathan, some of the foundation. I'm sorry about the moving of slides. It's not intentional. Jesus. Jonathan, give us some of the background on the substance over form and how that will lead into the step transaction.
All of what Marty kind of referred to as the mystical tax doctrines. The reason that they're mystical is when they came about, there was no law on point, and the courts began to say, this is just too much. You've gotten too much candy for your nickel. We're not going to allow it to continue. And the first case that really dealt with this was Gregory versus Helvering, who was the Commissioner of Internal Revenue. And that came initially in the Second Circuit by Judge Learned Hand, one of America's great judges of all time, and the Supreme Court affirmed it in the citation shown on the slide right there. Basically, what Mrs. Gregory did was a transaction which by the steps appeared perfectly to be allowed under the Internal Revenue Code. But they were very close in time, although time alone is not necessarily deadly. But she did these, and there was no reason the court found for this other than to get the tax benefit. So as a consequence, the court said, we're going to collapse these steps and treat Mrs. Gregory as though she had taken the last step rather than the first step, and they ignored the income tax effect of that. Again, these are almost all cases of income tax where you try to get something done, but the court found that at the end of the day, only reason you did it, which was for tax purposes. And as we'll get into, you need to make sure you can show some independence of these steps. In other words, that each step would have happened anyway. And as Tom said quite correctly, if you can involve other people in all the steps, different people. So you form an LLC on day one, and you've got 3 people involved, not just the husband and wife. And then the next step, maybe there's 4 or a different third party. You're really increasing the probability that it will be respected. And, again, all these mystical tax doctrines are really the progeny of Gregory versus Helvering. And by the way, the substance over form has been now enacted in the Internal Revenue Code, and all the doctrines you talk about that produce terrible results for the taxpayer are stemmed from Gregory versus Helvering.
And by the way, a simple way to have some independence infused into the transaction, have an independent corporate trustee and have an independent corporate trustee signing documents. Don't just do it by an assignment. If transferring, for example, an LLC interest signed by the investment trustee or advisor who may be the settler or the spouse of the settler or something, have an independent institutional trustee. In the Levine case, which was a split dollar insurance case, not relevant to our topic, but they extolled the client's use, the taxpayer's use of an independent institutional trustee. So that's something to give some thought to. Alan, Bob, any comments on substance over form, or I'm going to lay out the 3 tests and then we'll talk about them.
Well, just remember that email is evidence mail, so you don't want to send the financial advisor an email saying, hey, we're going to do these 3 things together to avoid the step transaction doctrine.
By the way, Alan's point,
think about
yeah,
the
go on.
second thing.
Alan's point is so significant. And even though he's saying it with a smile, it sounds simple or trite even, but it's really important. And I can't tell you how many times I call up somebody and say, please stop emailing me. I mean, clients, other advisors, sometimes even accountants and attorneys that should know better start saying things that is not what you want in the evidence trail. So there's three tests, and it's important at the outset to say there's no, just like Jonathan stressed in the beginning, there's no magic number of days that you can have between transactions. I remember John Porter making a comment at one of the institutes where he spoke, where he said 30 days is good, 60 days is better, longer is better still. We don't know how much time is magical. There's no question that people are going to show up at our offices and, way too late for what we're comfortable with. We could still do the transaction. We just have to make clear, and I would do it in writing to the client, that, there's a risk and you're accepting that risk. So there's no universally accepted time frame nor any universally accepted test, but the courts have relied on 3 concepts when evaluating whether a particular plan would fall by virtue of the step transaction doctrine. I'm going to name them and then we're going to talk about each of them. And these will give you concepts for how to plan better to hopefully be able to deflect such a challenge. The mutual interdependence test, the end result test, and the binding commitment test. And I didn't have it in the slide deck, but I will after this presentation. Alan's point, don't document in a letter, an email, or some other communication that what you're doing in the order and so on and so forth. So the courts will review whether the steps in the plan have to lean on each other to stand. If it's determined that subsequent steps must be taken in order to make sense, then the steps are independent. So you're going to do step 1, but step 1 doesn't make any sense unless you also complete step 3. They're mutually dependent. That's not what you want. You want to be able to have each step in the plan make sense on its own. I think you want to have, and I don't see this done enough, after each step, the kind of documentation completed that you wouldn't wait for the next step. So for example, if Alan and I, or Bob and Alan and I were setting up an LLC, we would insist on having a written signed operating agreement because we're 3 unrelated parties, and we'd want an operating agreement if we're investing in a deal. But too often clients, they may just have a very simple couple line assignment of the LLC interest, and they may not do a new an amended and restated operating agreement until 3 or 4 steps later. I think that's a mistake. I would amend and restate, if you can, the governing documentation so each step is independent. Your Honor, we could have stopped after this step. We have all the documentation independent third parties would have. Go on, talk about the Becker case. It was just a recent case that just came out on step transactions, so that's fine.
Yeah, so the Becker case recently came out. Dr. Becker was a dentist.
Recent, like just a week ago or so.
Right. Dr. Becker was a dentist, and he bought a life insurance 2 life insurance policies in an irrevocable life insurance trust. And in general, the insurance agent who sold him the policies paid for the initial premiums. And the life insurance trust owed the insurance agent's company the money for the premiums. And the money he paid was substantially less than his commissions. So then the insurance agent goes and finds one or more investors. They set up a separate company. They repay the insurance agent. They take an assignment of the note owed by the life insurance trust, and they enter into an agreement with the life insurance trust, which says, we'll pay your premiums. And when Dr. Becker dies, we want our money back plus a little bit of interest plus 75% of the death benefit. And Dr. Becker's family is going to get 25% or less of the death benefit at no cost. And this was done in 2 stages. Now, why was it done in 2 stages? Well, maybe the first reason is that the insurance agent wasn't sure what he was going to do, didn't realize he was going to assign it to some investors, and thought that he was going to do this because he was such a nice guy. The second theory is the whole plan was to get the investors to, in effect, and in substance, own 75% of these 2 policies. Well, Mr. Becker died unexpectedly in an accident, and it was time for the life insurance trust to pay the investors. And the life insurance trust said, no, you have violated Maryland law. This is a stranger-owned life insurance policy in substance. And instead of going to court, they settled. And the life insurance trust paid $8 million to the investors, but not 75% of the death benefit. The IRS came in, they reviewed Maryland law, and they said under Maryland law, if this was a stranger-owned life policy, the Maryland statute, which is just like the Delaware statute and dozens of other statutes, say, hey, the death benefit has to be paid to the estate of the decedent. We're not going to reward anyone who has a stranger-owned life policy.
Alan, let me go back and set the table a little bit. The law in all states says that if you are an unrelated person, you can't buy a policy on someone else unless they're a close relative, because it's really a form of gambling. So I can't buy a policy, say, on the life of Tom, because I don't have an insurable interest in his life, which means I don't have a reason for him to continue to live, or I would be financially harmed by his death. And some courts look at this more closely, others don't. But in this case, and you've got to remember, the IRS, I felt, was extremely clever in making this argument. They said, look, when you look at the substance of this, this wasn't that the decedent or the life insurance trust was paying for the premiums. They had these investors provide the premium. Therefore, they were paying for the policy. They basically own the policy. That violates this owner-controlled, independent person kind of deal where someone can buy a policy on the life of someone else. And I thought the IRS, and this is a lesson, the IRS, I thought, was exceptionally clever in coming up with this argument. So don't think, wow, the people in the IRS will never figure that out. They've tried to figure it out in this Becker case. Now, the IRS lost because there was real substance in it, and there were third parties. In fact, at the end of the day, it didn't turn out exactly as people had anticipated. As Alan said, the people got less than 3/4 of the policy proceeds. And I think that really helped convince the court that this really shouldn't be treated as a stranger purchased life insurance policy.
The interesting thing to me was that instead of applying Maryland law for the step transaction doctrine, the judge applied tax law when it was really a question of what Maryland law was. And then despite the $8 million settlement, the judge simply just says, sorry, but under Maryland law, there was no right of recovery. So I don't know that this case gives us much of an indication of how the tax law of the step transaction doctrine works, but it's an interesting application thereof. And the judge's discussion of the step transaction doctrine and the 3 different tests was at least a reasonable discussion. It was a tax court memorandum case, so it's not a binding precedential case.
But I think what's really important about it, and the slide deck, sorry, was not updated for this case because it just came out. But this proves that step transaction is alive and well known on the IRS radar screen. And despite the fact that it seems every conference and every SLAT article that anybody has seen talks about the reciprocal trust doctrine, uh, the step transaction doctrine may be disrespected by us as advisors as the far less important issue, but it's out there, it's real, and you have to plan for it. And that's why we wanted to do a program just on the step transaction doctrine, because it doesn't get enough attention, and it really needs to be. So the Linton is an older case that is really really an important case in the step transaction doctrine. And the court found in Linton that the different steps in the plan were just, and this is a key phrase, prearranged parts of a single tax plan. And they considered the steps to be interdependent and did not believe that the taxpayers would have done, say, step 1 or step 2 if they didn't also do step 3 and 4. So one of the things that's really important is as we structure and plan transactions, we want each step to stand on its own, like I said earlier, have completed signed documentation, infuse independent parties signing them so they're real. Make sure you put an actual date of signing, not just the date that things are effective in the documents, but also take a step back and ponder and think through what can be done in the plan that we're about to undertake to infuse more independence and reality to each step so that they could stand on their own. You ideally want any plan that if you got to step 3 and never got to step 5, if you could stop at step 3, what was done from 1 to 3 still made sense without going forward. And that's really important. So you want to identify and evaluate each step of the plan separately. Consider whether each step of the plan is independently meaningful. You got to think about it economically, legally. What's the purpose of the step? What happens after that step? Can we stop after that step? For any step that might appear interdependent, in other words, relying on other steps, try to consider what could be done to change the legal arrangements, the economics of the deal, so that that's not the case, and memorialize each step. Now, the real challenge that we're going to face as practitioners is time compression. It gets hard to do that when you have less time between the steps, but it's also fundamentally different than what many people do. So husband gives wife stocks, wife puts stocks in trust. So sure, if we'd have 30 days, 60 days, 90 days between them, the longer the better, to perhaps break that. But there's more that can be done. Why can't the wife take some of that money and spend it on something for her? Use it. Maybe she can go to a new investment advisor. The investment advisors won't like that, and have a new investment policy statement. But she could certainly reallocate the assets even within the existing investment advisor, sign a different investment policy statement, have planning meetings of how she's going to use the money she has. Not just be a way station along the way of taking the identical securities and gifting them. Nobody wants a circular transaction. The next test is the end result test. Do any of you want to comment on the end result test? So I'll go on and somebody interrupt if you want to comment. The courts look at what would happen, and this they're all kind of interconnected, but what will happen if you stop at an interim step? Like I said earlier, there's 5 steps in a plan. You want to be able to have that plan structured so that if you stopped at step 2 or 3, it still makes sense. You don't want it to be that it makes no sense to stop at step 2 or 3. The result is inconclusive. You really have to go all the way to the end and complete the steps. That makes them collapsible or capable logically of being aggregated in order to have a logical result. You don't want that. So if there's 4 steps, you want to be able to stop at step 2, have proper documents, a proper reasonable result that makes some sense. And we'll see that in the Smaldino case as an illustration in a few minutes. So again, you don't want steps in a pre-arranged plan.
Yeah, let me mention here, Marty.
Sure.
There are people who decided, for example, that they're going to create, say, a limited partnership and give away the units. And I've known situations where the clients came in on December 26, the LLC was formed on December 27, and then the transaction was completed on December 28. Who would not believe that they intended all those steps to occur? Pushing them so close together in time with the same attorney involved in everything puts you in a situation where you probably will be challenged if it's discovered, and you stand an excellent chance of losing.
And further, using Jonathan's example, what actually could happen in those few days that had any economic substance to it? What was the relevance of the intervening steps? We all will do transactions exactly as Jonathan just said, despite the fact that Jonathan said pretty clearly that you have a good chance of losing under a step transaction challenge. I don't think it's wrong for us as advisors, and maybe some of you disagree. If a client comes to me at the end of the year and I'm trying to help them, I'm going to put in writing to the client, listen, you have a step transaction risk, but if you want to get it done, so you use exemption because you got a couple of days left to do it, if not, it's gone, you're going to do it. The client's going to take the risk, but it should be the client's risk, not the practitioner's risk. By delaying, they've given you no chance. That is also why I think it's so important to get people started, clients started in 2024, because it gives you, I still like having things in different tax years. Even if Bob thinks it's mythical, I kind of like it. But it gives you more time to plan through the transaction. The final of the three tests is the binding commitment test. So if you have, for example, a memo of understanding that the business is going to be sold, and then you go and you make gifts of the business to different trusts, different family members, and try to do it at a discount, and then a month later, pursuant to the arrangement that was already agreed to, the business is sold. Those intervening transfers are going to be disregarded under the step transaction doctrine or the assignment of income doctrine, because it was already committed to sell it. And that's something that's really critical. In the case on slide 17, there was a year between the steps, and the sale did not take place until a year later. And the court still determined that the taxpayer intended to retain the stock. I'm sorry, and the court determined that they intended to retain the stock. So that's important. Timing matters. They held it for a year so the court didn't have to agree with the IRS that the steps should be collapsed. But again, you can go further. What do you plan on doing with it? Why would you hold it? Not leaving the intervening steps as just way stations to the final end step. And as we get closer to the end of 2025, that becomes more significant.
Marty,
What
let
I'd
me
like, sure.
let me say one thing before you turn to Smaldino. There are a couple of other cases you want to consider. One is a case called Ferguson, where people who controlled a company had an offer to sell the company, and the board of directors met and they decided, we're going to accept this offer. And someone on the board said, well, look, why don't we make a gift to charity or part of our stock? And that way that gain will be attributed to charity. We won't have to pick it up. Charity that we all care about will be benefited. This is a case called Ferguson in the Ninth Circuit. So they did that. And in fact, the deal could not be done without the consent of all of the shareholders, and not all of the shareholders were at that board meeting. But the IRS contended, and the Ninth Circuit agreed, that it was almost economically certain that the transaction would occur because the offer was just too good to turn down. So even if you don't have a legally binding commitment, which Marty was talking about, if there's an economic compulsion that the deal has to go forward, then you can go ahead and have a real problem. And this is a case where they weren't bound. You had to go to all the shareholders, but the court said it was so certain that it would be approved that we're going to say that the gain is attributable to the shareholders which own the stock, at the time of the board meeting and not the shareholders who had to vote on it and eventually approved it because the court was certain it would happen. There's one other case which you should be aware of, and it's a frightening case, and it shows that you can't say a particular period of time is okay. And that's the rather famous case of D. Goldschmidt Rothschild versus Commissioner, which is a 1948 Second Circuit case where Judge Learned Hand was on the bench, and where they went ahead and found that a transaction which had been done 5 years before was going to fall under the step transaction doctrine and be ignored, even though there were new players involved. Now you can look at that and say, well, this is all had to do with World War II because the taxpayer there was a Nazi. But the words are there in the decision that it was just certain that it was going to happen. And as a consequence, it did happen. And even though there were years between them, the taxpayer lost. So be very, very aware.
Let me take the comment that Jonathan just said and try to make it a little broader, because this is where I see a lot of planning less than optimally done. Often people, when they're structuring a plan, don't focus on the unique nuances of a plan. So for example, if we're doing a sale transaction, I've seen reps and warranties like totally boilerplate that have nothing to do with the transaction. Take the time, understand what the deal is, and tailor them a little bit so it looks like a real transaction and the reps and warranties make sense for parties involved in this particular deal. Conceptually, the same thing with step transaction planning. What is going on? What is the underlying business or asset? What can be done to show material, real economic differences from what we have here to what we have at the next step? So let's say husband transfers to wife an LLC interest, and we're going to see all the examples of what to do wrong in the Smaldino case Tom will cover in a second. But can we renegotiate a lease with an anchor tenant in a shopping center, right? Can we make distributions that are material? Can we take steps that show there was real economic substance while each step existed? If between steps you have a lease renegotiated, a new operating agreement that's not just changing the date and signatures, but maybe updated or changed or negotiated for different provisions in it, maybe a distribution, maybe all of the above. Tailor what you do to be real for the transaction. Takes a little more thought and a little deeper understanding of the transaction. So one of the cases that it came out at the end of 2020 in December, and it's a bad fact case, but Smaldino is almost like a checklist of everything you don't want to do to violate the step transaction. Tom, take just 5 minutes, but let's walk us through it, and I'll advance the slides as you tell me to.
Absolutely. So, like Marty said, Smaldino may be a bad fact case, but it's a good example of the kinds of things you need to look at when you're dealing with a transaction to attempt to deflect the step transaction doctrine. Just one point about the IRS very quick, because Alan brought this up earlier about Becker, and it's a really good point. The IRS is smart. It may not have the resources that it could potentially have, but they direct their resources in a way that's efficient. And Smaldino is a perfect example of that. So you have a blended family. Husband has interest in an LLC, and he has children from a previous marriage. He gifts LLC interests to the wife. The wife then, the very next day, makes gifts of those LLC interests to a trust that was created for the husband's children. So there's no interest for her to be in this trust because it's not her children that are beneficiaries of this trust. While she held those LLC interests, she didn't receive any economic benefit. She didn't sign any documentation on behalf of the LLC. She did not have the restrictions that are inherent in the operating agreement for that LLC addressed. So technically, they didn't even authorize her to be able to receive these LLC interests. And in the tax reporting for that LLC in the next year, there was no Schedule K-1 that was assigned to her for receiving that interest. So the family didn't really respect the fact that she had that interest, even if it was just for a day. So you don't just have the timing interests here. You need to look at the entire transaction and say, did the client and did the professionals respect the transaction and the interests of the wife owning this? And we don't have it on this slide, But when the wife, and this is a great point, was on the stand as part of the trial in this case, she said to the court, no, I was expected to transfer these interests. That was part of the deal. So another interesting point here is help your clients understand that's not a good thing for them to do. Just like Alan was talking about earlier with the emails, you can really hurt your own position if you're saying that this was all a fait accompli, it's always been done. Let's advance the slides, Marty. So how long of a holding period is sufficient? So Smaldino made it very clear, 1 day is not going to be a good look. Now, if we have the example that Jonathan said earlier of December 27th, the 28th, and the 29th, and you absolutely have to do that, put it in writing. It's the client's choice to make a risk. But what is sufficient? We've talked about 30 days. We've talked about 60 days. But in Holman, they found that 6 days was sufficient. But what was interesting there is that was they called it volatile stock of Dell stock. So that was something that was traded in those 6 days. A significant event could have happened. The stock could have gone down. It could have gone up. They found that there was enough of an economic risk there for 6 days to be enough. Let's go forward, Marty. So you really need to consider how much time do you have? What period of time are you comfortable with? I'm not going to belabor this because we've already talked about this. 30 days, 60 days, 90 days. Start now. Inform clients you really should get this going, because the longer you have, the better of a look it is for you. Let's go to the last slide here, because there's a good point about no bright line rules. Now, we've covered this a little bit, but make sure that you communicate to your clients that there's no threshold that you need to meet to make sure that the step transaction doctrine is not a concern. It's always going to be a concern because the IRS has the advantage of hindsight when they're looking at this. They're looking at the transaction as it ended potentially several years afterwards. You're in the trenches trying to get this done, and usually what often happens, and it's happened in 2012 and in 2021, the client comes to you after Thanksgiving saying, I need to get this done. I know that I waited, but let's just do it. So you need to be cognizant and thinking while you're there, how is this going to look 2-3 years afterwards, and how can we hopefully deflect the challenge that the IRS is going to bring up?
One of the negative facts in Smaldino is there was no K-1 issued showing the wife's ownership interest. Bob, I'd like to kind of pitch it to you to comment about the importance of the CPA being involved in this planning. The other thing that I've seen is some CPAs will sometimes try to help clients minimize tax reporting and complexity in K-1s by trying to avoid extra K-1s. But to me, it's really vital, and I think Smaldino points it out, I don't really care if it's a lot of extra paperwork and extra tax allocations to come up with the tax return. You want to make sure, I think, that the K-1s, because most of these are flow-through entities that we see, but not all, correlate exactly to the ownership days. What should CPAs be doing? How do we address that? How do we avoid that kind of issue?
Well, I think we avoid it between the professions by the best practice I've seen is lawyers will draft a very detailed memo to the CPA. Mr. and Mrs. Smaldino move stock. This is what you need to do on the compliance side. You need to do a gift tax return, make these elections, and then make sure the income tax returns for both Mr. and Mrs. Smaldino personally and for their entities reflect all this. And just lay it out. And it takes a little bit of extra effort on the lawyer's part, but make it easy, because what's going on in the CPA world right now, Marty, because of the shortage, people are moving from project to project at the speed of light, and they're not always able to say exactly how should I do this, okay? And they should, okay? I recognize that, but keep in mind what's happening is most of my CPA friends are working very, very hard. And if the lawyers can help them by laying out the transaction, giving them the documents, and then suggesting the compliance that has to take place, incredibly helpful.
Alan, any thoughts on that?
No, I want to interject something though. the Holman case, the Senda case, and these other cases where the courts have said when you put investments in an LLC and then you transfer a non-voting member interest in the LLC, you need to wait 30 to 40 days. I don't know that those cases are really telling you that it's safe to only wait 8 days when you're doing two transactions back to back. I think Holman, Senda, they're an aberration. They're just for some reason in a different universe. But people, I want to make sure everyone watching this knows if you're going to put stock or bonds or real estate in an LLC and then gift or sell a non-voting LLC interest a day later, think again. You need to wait at least a few days, if not a month.
Again, the only exception, we will all get clients showing up at the last minute, and we're going to do the transactions. Just what I would do, because of what Alan said, is put something along the lines of what Alan said in writing to the client. Hey, there's a risk here. There may be case law like the Holman case that says 6 days is enough. You have 8 days. It is a risk of significance. We can't quantify it. We're going to do what you've asked, but that risk is on you. The client can't then come back to you.
That's right.
Now, keep in mind what the concept was in Dell, because that may be interesting. The concept in the Holman case, not in Dell, forgive me, was that the Dell stock was volatile. We've seen massive movements of the stock market in very short numbers of days, right? There's some statistical analysis that, you want to be in the market on it's a tiny percentage of the number of days where there's massive upticks in the stock market. And if you miss those tiny number of days in the course of a year, you lose out on a lot of the upside in your portfolio. There is risk in the market. Maybe it's a real estate LLC that you're making a transfer of, but maybe the anchor tenant who everything's dependent on is a publicly held company that's very volatile, right? What happened to the Martha Stewart Omni stock when her reputation was in question? When her reputation was humming, it skyrocketed. When her reputation was challenged, the stock tanked very quickly. We can have look to support those facts before you do the transaction if you can, if you don't have the luxury of days. Let's and I'm going to ask any of you to comment and jump in. I just want to add some comments to try to give guidance to our colleagues listening on what they can do to better structure transactions. So, for example, and I'm going to just short circuit the hypothetical. People can read it later if they want, but I just want to focus on giving some practical steps that may help people. So, if we have transfers to an account, one spouse gives the other spouse assets. Maybe you hire a new investment advisor. Maybe they're thinking of changing. If they're comfortable and happy and have a long-term relationship with their investment advisor, you're not going to do that. But create a new financial plan. Look at new things. Lots of clients that are transferring marketable securities that may be used in a plan haven't revisited their retirement plan or their intent on buying a vacation home or other financial goals in years and years and years. Well, maybe that's something that can be done after the transfer by the spouse that gets it. We have a client that is making interspousal gifts, and they've talked for a long time about changing zoning, restructuring the entities that own it. All that's going to be done after the initial gift. So think about it. If let's say wife is giving husband an interest in a rental shopping center that is actually surprisingly owned outright, not even in an LLC. Husband puts it into an LLC, renegotiates a lease, takes a distribution. You are creating some significant independent economic events that all involve third parties. So if wife makes a transfer to husband, let husband withdraw some of the money and use them for living expenses. Let him purchase some toys. Let him have some fun with it, as well as creating a new investment plan. Maybe people keep their assets separate, so the initial funding of the trust isn't from monies that was transferred from wife to husband. Rather, husband uses premarital assets to fund the trust in 2024 and sits on the gifts and does all the things we just talked about and doesn't make a transfer until 2025. disjoint the gifts. So if wife gave husband 7 or 8 million, maybe only 5 million goes into the trust from that source. So there's steps that can be taken that can really help support the break in the 3 different tests that we talked about earlier. Any of you want to make some comments about some of this planning?
I think Jonathan's on a short timetable, so maybe he should go first.
Well, as Marty said, you've got to have some independence. And one of the things which Tom said and Marty said before, if you have different corporate fiduciaries involved and they have to make the decisions, I think it goes very, very far in protecting you. So you will have a client who will come in, no doubt, on December 27th of 2025 saying, hey, we want to do some transfers. But if you make sure you don't fall under some sort of reciprocal trust doctrine, if you have independent people who get to make the decision, you stand a much greater chance of being successful. Also keep in mind that there will be so many gifts in 2026. That 2025, that you're going to probably have the benefit of maybe not being picked up. Again, it's best if you can choose different tax years, but if you do one in 2025 and follow up in 2026, it may be that the IRS will try to put those together.
I just like to say that not everybody needs a slat. I mean, it's nice if Marcia would set up a trust that I could be a beneficiary of, I could have a power of appointment. But what if she just sets up a trust for our descendants? What if my brother-in-law is the trust protector, so I don't need a power of appointment? My brother-in-law would do the right thing for our descendants.
By the way, Alan, I assume that's not your wife's brother, but your sister's husband. Because, remember, blood is always thicker than water. The difference between in-laws and outlaws, Alan, is what? Outlaws are wanted. So if you set it up, remember this person to whom you're married and shared your most intimate moments and cared about the most, all of a sudden becomes your most vicious and terrible, adversary when it comes to wealth. So I would not rely on someone's, the spouse's own blood to do the right thing by me. But Alan's point is a good one. If you have independent people who have to approve it on both sides of the transaction, and if they will come in and verify that there was no, binding commitment, no end result that was assured, I think you stand a greater chance of winning. And that brings up one of the things that we will probably have a program on SLATs, spousal lifetime access trust, where Alan creates one for his wife and his wife creates one for him. But instead, one of them would create what we call a SPAT, a special power of appointment trust.
Don't give it away, Jonathan. We're going to do a whole separate program on that.
But this is
but everyone, we broke out. We're doing this program just on step transaction. We're doing a whole separate program on reciprocal trust because these doctrines are really important and they need more attention to make planning succeed.
Marty, that's true. But again, all of these fall under the mystical tax doctrine, and it all goes back to Gregory versus Helvering. That's really where all of this begins. So as a consequence, the more you can do to make them different, to have independent people involved, the less that the transferor has an opportunity to get it back directly, but maybe just becomes a beneficiary of a discretionary trust, the better off you're going to be.
Agreed.
Marty, I just want to bring up one issue. If these transactions blow up, what happens? So I was just retained by a law firm to run numbers on a very large project. And basically it's husband is gifting $14 million to his wife. And then she's going to turn around next December and make gifts to his children. And the lawyer very wisely recognized the risk. And he said, Bob, just show me on a pro forma Excel spreadsheet what happens, how the IRS might attack this. And not from a legal perspective, but mathematically. And what is that going to mean? And it's a very good idea to run those numbers, because sometimes you can live with the result and sometimes you can't. The other thing in a case like Smaldino, they would have deemed the husband made the gifts directly. And if he and his wife gift split on something else, arguably he could still have half the gifts coming from his wife, because the goal of giving to his wife was to use her exemption. You could get in a common law or state where the property was not community property, you can use gift splitting to avoid all this. So you don't necessarily have to have H gift to W and then W to his children. You could just go H right to his children and gift split. So I think sometimes we might make our life more difficult.
Let me ask Alan, maybe you as well, Bob. Smaldino was the wrong plan. If you had that compressed of a time frame, and I'm not sure they had to have it done in that time frame. I didn't recall anything from the case that said they had like a sale pending and they were trying to do it. But if you need to get something done quickly and you're trying to shift value, why couldn't they have done a grat or a note sale to the trust by husband? He had the asset. Don't do this fictitious step transaction through the wife. Sell the assets. You can lock in a discount, right? You get future growth out of the estate. You still have grant or trust burn, which is meaningful. Wasn't it just the wrong plan? And I guess the bigger question is, when we're doing a plan, we need to step back, because maybe the step transaction doctrine can be avoided by just doing a different plan if the risk seems too material. Thoughts, comments?
Yeah, Smaldino could have just done a slat for his wife, and it could have had a floating spouse clause. He could have had one of his siblings have a power of appointment over that trust, and it would have worked just fine. Before I forget, I just want to mention, when you draft these trusts, you could put in a savings clause that says that I'm funding this for my husband, but if it turns out my husband is actually funding it, then he won't be a beneficiary as to the portion he's funded, and he won't have a power of appointment over the portion he's funded. Maybe if that had been in the Smaldino trust, they would have settled this matter, or it wouldn't have been a problem. And then I think another thing to keep in mind is, yeah, it seems like you should use the $13 million exemption before the end of 2025. But if you're going to live 30 years, it's just as good to make a $2 million gift. And like Marty said, do a $20 to $30 million installment sale. And over a period of time, that will have a better impact on estate tax planning than making the large gift. The other thing I want to mention is, what if Mrs. Smaldino owned a home? She could have transferred that to Mr. Smaldino in exchange for this stock. What about her marital rights? There's bankruptcy.
No, Alan,
Yes.
there's no income tax consequence for him, Mr. Husband giving wife, spouse one, spouse two, giving her the interest in the LLC and her buying it for the house because they're married, right?
Right. 1041.
That's an important point in what you just said, which is a great idea.
Right. Or give, if I'm going to buy a lot of assets from Marcia, I'll just give her a large promissory note and I'll actually pay the note over time. There's bankruptcy court cases where the bankruptcy court says that if you give money to your spouse in exchange for the release of marital rights, that's an arm's length transaction. Maybe Mrs. Smaldino should have signed away her marital rights in exchange for these assets so that it would have been at arm's length. So there are different things to do, but our firm formed, I don't know, 100 trusts in 2012. And we don't know of any clients who have taken money out of any of those trusts. So do you really need a slat? I mean, if you're so wealthy that you're doing this stuff, do you really need your spouse who's giving you the assets to be a beneficiary, or is this a reptile brain dysfunction? I don't know, but that's something to think about.
I agree with you, but I think a lot of times it's just fear of the unknown. I would not want to make a transfer and not have a way of accessing it. But I think that the key point to what just came from what Alan said and Bob said in my comments is that think through broadly. So often a client will come to us and say, here's what I want to do. Okay, this is what you're trying to accomplish, Mr. Smaldino. You're trying to get these this real estate LLC interests to a trust for your kids. But as Alan just pointed out, there's maybe 3 or 4 different ways you can go about that. Why do the way that seems to have the most risk under the step transaction? And we can't quantify any of these risks. Smaldino was bad facts. It shouldn't have been done that way. But offer client options. And by the way, one of the safest things to protect us as practitioners from a malpractice claim, offer the client options. Tell them pros and cons. Let them make the decision. There's pros and cons to everything. Alan is right. Lots of the clients, most clients that set up these slats never access them. But on the other hand, you don't want to be sued by the client because they need money and they can't get at it. Let the client make the decision. Give them options. But it looks like Smaldino, and it's so common that we all see clients that come and say, here's what I want to do. Okay, take a breath. We got what you want to do, but here's some other ways that may be better. And that may have solved the problem. I rarely see the kind of interspousal sales that Alan talked about. I don't see an income tax issue or gift tax issue. They're married, right?
The interest on the note will be taxable for some strange reason, but otherwise, not a problem.
So take a look at the options. Give respect to the step transaction doctrine. It's too often ignored. Alan, tell me the name of that case, that new case that just came out. I'm blanking on it.
I don't know, but it was Dr. Becker.
Yeah,
No,
maybe
I have the citation, Marty.
give it to everyone.
TC memo 2024-89, Larry Becker.
This is real, folks. Brand new case. What's the most recent step reciprocal trust case that you guys remember? It's a while.
Green, Bishop, somewhere in there.
Those are more than a couple years old, are they not?
They're over a decade old.
Okay, so everybody talks about the reciprocal trust doctrine. That's why we wanted to do a program on the step transaction doctrine. It's real, and the Becker case proves it's on the IRS radar. There is a bunch of different facts and discussions in the following slides on how to address timing and economic differences. I believe we've covered these points in the concepts that we've talked about earlier. But again, to me, the big take-home point is you want to address the formalities. You want to do it properly. You want it properly documented. The Sorensen case, so many of the cases where there were issues of things being disregarded and the taxpayers not winning, they ignored the formalities. They didn't have all the independent documents. Sorensen was the Firehouse sub case, and their Wandry valuation adjustment clause was disregarded because they didn't adhere to it. They didn't document in sales and other transactions that it was a dollar value, not a percentage. You got to make sure the documentation is right. Another key point in Smaldino, I'm not sure we said it, so I just want to emphasize it. The court was very unhappy with the fact that documents were signed with an effective date, but no actual signature date. If the concept underlying the step transaction, one of the concepts is time between transactions, and I think it's just as important, maybe more, what economic and legal substance is between each of those steps. Every document, and corporate counsel, commercial counsel will often create documents between unrelated parties with an agreed effective date, and that's fine. They often don't put down the actual date signed. I'd like to have dates signed. Even if it's not required to be notarized, if we have the ability to get stuff notarized, why not? It's just confirming with a third party that these transaction steps happened on those dates. Make it look real. I'm going to let each of you, Tom, start with you, give any final comments, thoughts, then Alan, then Bob.
So I just want to reiterate a couple of comments that we've had as themes throughout this entire point. There's no bright line rule with the step transaction doctrine. There's no magical number that you need to reach so that there's no concerns. That's something that you should really be communicating with your clients so they understand that they're taking a risk. Even if they wait the 30 days, even if they wait the 60 days, 90 days plus, there's no way to tell how the IRS is going to challenge this. Another point is the hindsight ability of the IRS when looking at these transactions. We're doing these in compressed timeframes. We're doing it for these clients that come to us on Christmas Eve or on December 27th saying, I want to get these assets out of my name. The IRS is going to have the time to pick through what you did, and they're going to find all of those issues. So be cognizant as you're doing this planning of the potentiality of a challenge, and infuse your planning and the options that you provide to the clients with that thought in mind.
I want to thank Tom for committing to be in the office on Christmas Eve. Since this is recorded, I will have evidence. Alan, any closing comments you'd like to make?
Let's just think about if you have trusts that are already in this situation, maybe the client's older with less need to control. Maybe trust protectors can be appointed and take away this power of appointment, take away this withdrawal right. So get that done 3 years before the client dies, so you don't have these risks necessarily. And then talk to the clients about an asset protection trust and an asset protection jurisdiction where the trust protectors maybe could add you back, but only if and when your net worth drops precipitously, so that it would be an active independent significance. That seems to me to be safer than doing a slat and risking the step transaction doctrine over the next 20 some odd months.
Bob?
Marty, for our CPAs listening, A is if clients have not always already retained someone to help them with this in the next 13 months, let's get them to a lawyer that can help them right away, because many of my lawyer friends are going to close their practices in February, March, April, and just say no more clients during 2026. It's inevitable because they're feeling overwhelmed with the amount of responsibility they already have. Secondly, work very closely with the client's lawyers and ask them either to sit with you and tell you what compliance is going to be required, or better, to give you a memo on the transaction and what tax returns are going to be required from that. And the third point is for the lawyers, don't be afraid on some of this to reach back to the CPAs to have them model the transactions, either by building Excel spreadsheets, using software like the software Alan and Professor Hesch have developed that I was involved with a little bit, and also, or just dropping things into pro forma tax returns. And Smaldino would have done perhaps a better result. Obviously, they need to build in more time, but they totally missed putting her interest on a income tax return. And that was shameful. That was really bad. And I'm not sure if that falls on Mr. Smaldino. He probably didn't tell his CPA that he gifted property to his wife. And that's where the lawyer should have just shortcutted him and got permission to talk to the CPA or send the CPA a memo.
By the way, Bob, you may not recall, or maybe didn't know. Do you know what Mr. Smaldino did for a living before he made a fortune in real estate?
Wasn't he a CPA?
Yes. You would think he would know better. Gee, wife owns it, I'm going to issue a K1. One day ain't quite enough. Read the Smaldino case, folks. It's not a long, hard read, but it is a veritable checklist of everything you don't want to do to avoid running afoul of the step transaction doctrine. Be much more thorough in your documentation. We see mistakes all the time, shortcuts all the time. If a client's pressuring you, no, I'm not going to amend and restate the operating agreement. I'm not going to spend the couple of hours of your time to do it. Just do the assignment. I'm done. I don't want to spend the money. Put in writing, dear client, I told you you should do complete documents, including the following, and you refuse to pay for it. Clients should not short circuit what we can do. I think Bob is spot on. And with all due respect, I'm going to blame a lot of it on the clients, but some of the fault belongs on us lawyers. We don't often or sufficiently communicate with the accountants what they have to do. Lawyers sometimes don't appreciate the importance of the compliance function. It's not routine. Compliance is essential. If the tax compliance doesn't reflect the transaction that the lawyers did, there's going to be a problem somewhere, whether it's with family members, with creditors, with the IRS. You want to make sure that the tax compliance coordinates. And a lot of the fault for that goes on clients because, oh my gosh, you're going to have my lawyer and my accountant on the phone together. They're both billing me. Okay, but do you want it done right or you want it done wrong? And the final point, and I know I've said it a few times, but I think it is the most common issue I see with step transaction concerns. Look at the underlying economics. Look at the facts in the particular case. Every case has somewhat unique facts. There's always ways you can find to differentiate, make economic substance, create economic reality between steps if you look deep into what's actually going on. And too often that's not done as we just are rushing through transactions. I hope the program was helpful to all of you. I feel the step transaction doctrine, especially in light of the very recent case, which we will update our materials for the next program on this, Becker, is something that really needs to be on everybody's radar. And if you can get any pieces of a plan done in 2024, it gives you not only more time, but independent tax reporting, as Bob explained earlier. And I would encourage you all to do that. So I wish everybody good luck. I want to thank Jonathan, who had a jump, Tom and Alan and Bob for participating. And if you have any questions, email the speakers. Our email addresses should be in the materials, and if not, we're all easily findable. Thank you for joining, and good luck with your end of 2024 and pre-2026 planning.
Thanks, Marty.
Thanks, everyone.